Greetings, everyone. This is Richard Solomon, and welcome to Taking Care of Business. This week, our special guest is fellow small business attorney Tristan Loanzon, and he can be found at 212-760-1515. And just in case you need to get that number down, his website is loanzon.com. All right, Tristan, welcome to the show. Appreciate
thank you.
So let's get right into all the small business dynamics. As you know, a number of people who are listeners and YouTube viewers are very interested as either small business owners or small business vendors. In pre-production, we were talking a little bit about some of the things that really jam up small business owners and get them sucked into either litigation or incredible expense. Let's start our talk today with boilerplate contracts that are presented to various business owners.
Yeah, be happy to. I've seen a lot of small business owners come to me and complain about a default judgment against them, a lawsuit against them, brought by essentially vendors who provided services or goods to the small business and have decided to basically sue on the contracts that the small business owner signed. Like, for example, I represent a deli, and this deli owner signed a 2-page agreement that's for credit card machines. And these agreements are very tiny. The letters on these agreements are very tiny.
You need that electron microscope to read the small print?
Yeah, they're like 6-point font. So you gotta, he signed it, and he, as a corporation, his entity, and there's a personal guarantee on top of that. So if his corporation doesn't pay, then the personal guarantee kicks in, and he gets personally liable for any debts or invoices that are not paid. So lo and behold, he signed this several years ago. He decided there were some problems with the credit card machine. He got rid of it, and then he got sued. He was served, but apparently was served defectively, meaning that they just posted it in his store. They couldn't find him, posted it in his store. And then next thing you know, he didn't answer because he didn't see the complaint. And then next thing you know, you get a judgment. A judgment not just against the corporation, but against him individually, personally. So they then decided to send the marshal to his house and serve him with the judgment and serve him with a restraining notice, basically freezing his bank account. It's a nightmare. Small business owners wouldn't want this kind of nightmare, but it happens all the time. So
it does, unfortunately.
Yeah, so these contracts are these small print contracts need to be reviewed by these business owners. I understand that sometimes they don't have the knowledge, they don't have the English fluency to read them, and sometimes they just don't consult any expert. A quick run through them would benefit them greatly, but happens all the time.
Let me share with you a war story, since it's important. There's a well-known, I don't want to give anybody's names because there's a lot of litigation with these people, and they're big and tenacious, but they're a kind of like a media company, just loosely defined. But what they do is they go out there and their salespeople make one representation. They whip out a contract, much like the one you were describing, to have your services listed in a certain venue. And of course, there's the boilerplate language, and it says that, of course, by signing, you're personally guaranteeing it. It's buried in paragraph 9, in the back somewhere. They are ruthless in that if there's a mistake or something like that and there's a dispute, they turn around and they sue you. Then they sue you for everything, including like what they call acceleration clauses. For those out there, it's like everything that you could owe us under the contract, under the default, it's all accelerated. Now you owe the whole shebang, and then they sue you personally. And then, as Tristan noted in our discussion before the show, sometimes you're subject to lawsuits outside of the state you actually do business in. Why don't you talk about that for 2 seconds? Yeah,
this particular deli owner, the contract says he's agreeing to be sued in Michigan. He has no connection to Michigan, never been to Michigan, but it says it's your consented jurisdiction, exclusive jurisdiction in Michigan. So they got him in Michigan. There's a judgment in Michigan, which then they recorded here in New York, and that's when they're seizing him on. So it's not only he's liable for the actual invoice amount that's not paid, but it's also for attorney's fees. There's a small provision there that says attorney's fees, costs, and disbursement. So on top of the injury you also have to pay the other side's attorney's fees. And then the real kick sort of is this. Let's say you really let's say you actually work with an attorney, believe it or not, and you have somebody you really like here in New York. Well, unless that person is barred in the state of Michigan, you now have to hire a new guy, and I mean that generically, a new lawyer in Michigan who has to go in to the courts in Michigan and under Michigan law try to vacate that judgment. And depending on what the rules out there, you may or may not be successful. And a lot of these, Rich, cases are brought in the civil court. This is the small court in New York City. Different counties would have different civil courts. And these civil court judges, I've noticed, are really enforcing. They're enforcing these agreements. I've seen maybe one or two judges that say, no, I won't enforce this clause regarding being sued in Michigan or whatever state, because it's the defendant has no connection at all to any of these jurisdiction. But that's rare. Most of the time, the judges would say, hey, you signed this, right? You signed this agreement, you consented to it. So they're enforced. So it's hard. It's difficult to win them. In short. So the bottom line is, don't sign. Yeah, or just I think you have power to negotiate. I think there's a leverage issue here. I mean, you can change these boilerplate agreements. I regularly tell clients in small business that whenever there's a venue clause outside of the county or state that they're in, not to sign it, don't do business, and they're just going to get hauled into some foreign jurisdiction. I mean, foreign, just out of New York, and they'll have to litigate, and that's never a pleasant experience. Speaking of unpleasantness, we also want to talk a little bit about auto renewals. Talk about that and with the context of that. Yeah, most of the time, a lot of these agreements would have a provision that's in small print that says, the term expires after, say, a year or 2 years. If you don't give me notice, if the business owner does not give notice within, say, 90 days or 60 days before the expiration, or 6 months, the contract automatically renews. So there's this statute in New York called the General Obligation 5-903. So if you're listening to this, just write down General Obligations 5-903. If you face one of these automatic renewals, that's your friend. That's your statute friend. You grab it and you say, okay. Well, it says the whole history of it was, the legislature decided to protect small businessmen from unwittingly signing these agreements. And so what they did, in the statute said, if there's an automatic renewal in any contract that you have that deals with both real property or personal property, the the vendor trying to enforce the contract must notify you, the small business owner, at the latest 15 days before the time it needs to be renewed, in writing, by certified mail, that it's supposed to be renewing. So before it renews, you're supposed to get notice. And if you don't give the notice, if the small business owner does not get the notice, the automatic renewal is void. There's no automatic renewal. They also call them the evergreen clauses. So there's no renewal, so therefore, as a business owner, you can terminate at any time. The problem is, if a lot of times business owners don't see this, they don't know what the statute is. So the 5903 is something they've never heard before. So the contract keeps on renewing, and they think they're stuck with it, and they keep sort of paying and renewing it. But you have a friend out there, and you got to sort of look at these contracts and make sure that you understand, especially if it's something that deals with personal property. You think, does that mean like toothbrush or something like something I own personally? No, it actually means it could be the canned goods you have in the store that you're selling. It could be the potato chips that you have there. It could be the beers and those are all considered personal property. So you got to watch out for those. I think it's. I have a war story.
We love war stories. We're all about war stories.
Well, I represented a doctor in a who's faced this automatic renewal clause. So the provider of the services to him said, hey, look, your contract automatically renewed for the next 3 years. So it's a 3-year contract, and he didn't see that there was an automatic renewal. It was renewed, and so the guy, the vendor that sued him, said it's for 3 more years. You renewed this. The court actually agreed with him. The court agreed that it was renewed 3 more years, and that was a lot of money. So essentially, the small business owner, was stuck with 3 more years of payment. So he came to me. He's like, "What am I going to do with this?" I was like, "Well, let's see what happens." So we defended it. We lost in the trial court level. Trial court said, "Oh, you owe this guy $600,000." $600,000. So we appealed that to the First Department, in Manhattan, and the appeals court reversed the trial court. So we erased the $600,000 judgment. We invalidated the contract. And it was a big win for the doctor. It's a big win for a small business owner. So I was happy about that.
But what about in the next minute and a half before the break? What was the stress like for the doctor? Facing was essentially a business killing, potential judgment. I mean, the stress, the legal fees, the uncertainty.
The legal fees he had to pay me. The legal fees. In the agreement. The agreement itself has a legal fees provision that he was supposed to pay the attorney's fees of the prevailing party. Since the plaintiff prevailed, his vendor prevailed, he had to pay the attorney's fees for the other side. So now there was a judgment in trial court. The plaintiff, they're wicked. They basically enforced the judgment. So the day before Christmas Day, just this last year, they restrained his bank account.
Wow. That's brutal.
Brutal. They restrained all his money.
Let me hold you right here. You need to stick with us. You're listening to Taking Care of Business with Richard Solomon. Our special guest is small business attorney Tristan Loanzon, 212-760-1550. LOANZON.com. We'll be right back. Stick with us. A lot more to cover on this show, all about small business tip strategies and winning strategies and hopefully tactics. We'll be right back. Stay with us.
What I really need, some kind of affection.
Richard Solomon, Taking Care of Business, tcbradio.com. You can catch us on YouTube at TCB Radio. If you look under TCB Radio, but the specific address on YouTube is youtube.com/user/TCB Radio WCWP. We are talking to small business attorney Tristan Loanzon, and we're going over some sort of nightmare scenarios for small business owners. We're trying to give you tips and strategies on how to stay safe and keep out of danger. And he was just remarking about a client of his who had his a very significant judgment rendered against him, in which he was notified, sort of by force, of the I guess it's the executive department of government. Usually it's the sheriff or the marshal, with a levy, as they call them. Why don't you pick up from there, please?
Yeah, quickly. So the day before the holiday, the Christmas holiday, he received a restraining notice, basically he went to his bank, tried to get some money for payroll. He was told that his bank accounts are frozen, so he couldn't pay his employees, couldn't pay himself, couldn't pay his rent. So he put all his money in this one bank. And all his checking, his personal checking, his business checking, they're all restrained by the judgment. So this business owner is facing a catastrophic, nightmarish situation and not being able to pay anybody, even his vendors, his rent. So we had to go to court and spend a lot of hours in court making motions, trying to lift the restraint, trying to lift the freeze. It was a nightmare. I mean, this doctor was basically at the end of his lifeline, and fortunately, some family members helped him out, but we couldn't lift the restraints, and not until the beginning of January. So all throughout maybe 7 days, he was just out. So you don't want to be facing that situation. So you got to review your contracts. Make sure when you receive something, a summons or something like that, you got to face to it. You cannot ignore it, because at the end of the day, if there's a judgment, there's 20 years. The judgment creditor has 20 years to enforce that judgment, and they have a whole slew of tools to try to enforce it.
Including taking your deposition, meaning your testimony under oath, where they can ask you, where's your money? How do you make your money? Do you have jewelry? Do you have a coin collection? Do you have artwork? Do you have a car? Do you have a boat? And they can go through basically every single thing. How do you pay your rent? How do you pay for this?
Right.
Well, where do you live? Who else lives with? They could really, and it's brutal.
Right.
It's actually a brutal process.
Well, one thing, one sort of strategy for a business owner on this is that they should always separate the business from the personal, right? I'm sure you tell your clients that, Richard.
And different banks for, you bank personally in one place and different bank for your business. And I use different color checks so that you don't make a mistake and everything. You got to keep it. It's what they call the theory of islands. You want lots of islands so that if there's a plague on one island, just run off and go to the next island.
Right. And the law, actually, the law sometimes would pierce the corporate veil. That's the sort of the term of art in the law, that if the corporation and if your corporation and you as a business owner are treating the bank account the same, like money flows in and out of the bank account personally and for the business, and you don't distinguish the two, the court's going to say if there's a judgment that's against a corporation or the Inc., that judgment is going to go through that corporation. It's going to go through you as a person. So what you want to do is basically put up that wall. You always got to make sure that you always put up that wall between your business and yourself. And one of the strategies is keep the checking accounts different, the banking different, the banks different. Try to keep the books different, So don't just sort of take money from the cash register and put it in as a sort of personal cash. But so those are the things that small business owners like me and you, Rich, can advise people on, because when the corporation gets a judgment against it, usually it just stays with the corporation. That should just stay with the corporation. But there's this thing called piercing the corporate veil, and that happens to business owners who don't treat their business as a separate entity.
That's right.
They always should.
So when you get that haircut, don't charge it to the business. It's a personal expense. And my advice for all those listening out there is you really need a very good accountant to sit down, organize your books and records, show you how to allocate everything, how to categorize everything, what are the do's and don'ts, because that will do a lot to really keep you in a good place.
I agree.
All right, so let's move on to employment law. I know that you do a lot of employment-related legal work. Let's talk about sort of the later topics. We have all the different kinds of discrimination and wage claims. So why don't you talk a little bit about that?
Yeah, I think there's really two major categories of employment claims that small business owners face. One, and the more common one is really the what you call Fair Labor Standard. It's FLSA. It basically says if your employee works over 40 hours a week, you're supposed to pay them overtime and etc. So that's a lot of that claim is being brought against restaurant owners, against small deli owners, because they employ a lot of people who, I think a lot of them are immigrants, and they decide to pay them sort of $6, $8 an hour, and regardless of how many hours they work. So that's a major category of lawsuits. The other category is really, the employment discrimination cases. Those are usually cases that are brought against, sort of middle-sized, medium-sized corporations in New York. I don't see those kinds of cases against sort of the small business guys, the small business owners. Mostly it's sort of a falsa claim, the first one.
Well, let's talk about both because we have all kinds of people who listen. So in the Fair Labor Standards case, how long is the owner liable? Is the owner personally liable or just the business? If it's just a business, if you're operating your business like a business, separate from you as an individual, it just stays with the corporation. How long? It goes back 3 years. But if there's a willful violation, it will go back 6 years. And how do they determine what's willful?
The allegations in the complaint would basically say, he knew this was going on. That would be the allegation that they knew it was going on, and they were really sort of trying to underpay us. They pay us in cash. They don't report it. Those are sort of indicia of willfulness.
Badges of fraud.
The badges of fraud, and they go back 6 years.
Now, I tend to notice that these cases usually are in groups where it's multiple groups of plaintiffs will sort of join forces under one lawyer or one lawyer's banner, and then you'll see I've seen these. You get a letter, and it says the following you owe the following people X dollars, and we get this plus attorney's fees and some other stuff, and you're required to give us the books and records. So it appears to me, because I don't do this kind of work, that you could be sued and have to give the information even though the other side doesn't seem to have any proof. Is that more or less correct?
Yes. The last 10 years, FALSA cases have really sort of rocked the small business world, the restaurants and deli owners, because the plaintiffs' lawyers have become very sophisticated at sort of getting at these workers, right? They'll have these I've had clients, business owners, who just say these plaintiffs. The way plaintiffs got to the lawyer was the lawyer would have advertisements in sort of an immigrant channel, at night, at midnight till 5 a.m. So when these guys come back from, their whatever restaurants or deli, they go home, they watch TV, and they saw these commercials of guys who says, I speak Spanish or I speak, French, and, come to me if you just came back from work and you never got paid overtime. So they're treated as what you call collective action. It's not a class action where everybody gets together and everyone belongs to a class, and then they opt out. They have to opt out. Here, in FALSA cases, it's called a collective action, meaning if one employee is suing, it's not automatic that the other employees are also, who are similarly situated, are part of it. They have to opt in. So it's an opt-in rather than opt-out. So they have to jump into the lawsuit. Do they need records? They just need to make allegations, right? The last 10 years, all they need to make is allegations, and then they go through discovery, and that's pretty expensive. But recently, in fact, the Second Circuit, or the court in New York, have said that these complaints have to be subjected to the same pleading standard in cases called Iqbal and Twombly. That basically they have to have facial plausibility. You can't just say I worked overtime, right?
And you owe me big time.
Yeah, you can't just say it. You now have to sort of state exactly what happened. There's a case called De Jesus in the Second Circuit. DEJESUS. Forget the name of the second party, but De Jesus basically said the standards, the heightened pleading standard in cases called Iqbal and Twombly are now are applicable to FALSA cases. So the Second Circuit actually has thrown out a bunch of these cases that are not well pleaded. So there's some relief coming. The pendulum is swimming back to the middle.
Right, but I assume you don't need much in your pleadings. By the way, for those out there, pleading is basically the writing that sort of summarizes and gives notice to the other side of what your claim is. It doesn't have to be really, really exact. We live in what's called, in New York at least, a notice state, where as long as you give notice of what the problem is, that pretty much passes the legitimacy test of what the courts will accept. So
it's difficult to win these cases too. I mean, the reality of it is, that's the sad part of this, is that when you get sued, and usually you get sued in federal court, which is different from the state court system. In the state court system, things kind of move slow. You'll get time to sort of answer, to go putz around. I'm sorry, but to the discovery. But in federal court, things move a lot faster. So a lot of judges sort of say, come on, let's keep this case moving. And so a lot of times the small business owners are really under the gun. And most of the time they settle. Because they know most of the time they can't win the case. Because the problem is they don't keep records.
Or their records stink, yeah.
It's as simple as just giving time cards, right? If you have time cards, for example, I represented a deli, a grocery, where he had his employees punch time cards. So every time they come in, they punch. They come out, they punch. So when they sued, they said they work overtime. He just looked at he made copies of the time cards, and he produced it. And they said, Your Honor, I have records, and that case was dismissed. But not everybody does that. So if you don't have records, it's presumed that you didn't have any records, and it's presumed that the employees did work overtime and you didn't pay them.
Wow, and the truth is there are problems out there, which is why you need good accounting, good payroll, good records, time cards. The problem also is, one thing kind of leads to another. You have a lawsuit like this. Now you're on the radar for someone to do a payroll audit, because then you didn't pay enough money, and then you didn't pay enough payroll taxes, and then you didn't do this, and you didn't do that. And then, or if you paid people off the books, and all of a sudden workers' comp says, hey, you underreported the number of employees and this and that. It becomes a problem. I was at a tax seminar at Long Island University, and they said that the New York State policy is now to really look at various kinds of tax issues and find other criminal tax problems that are associated with it. So let's say, or just criminal activity. Like, so let's say, for example, you're in an illegal handbag business. Well, they're going to grab you also for not paying the tax, the sales tax. So it just pays with all the computers out there and all the surveillance and all of the things that they, meaning government, can do. They have an enormous arsenal, and they can really go after you. And the cost of defending is really dramatically tough. Let's switch over because this is going really, really fast. The different kinds of discrimination that medium businesses face. Age, gender, ethnicity, orientation, that kind of stuff. What do you see and what do you advise?
Yeah, it's if you have been terminated, I mean, a lot of times employees feel like they were terminated for reasons that other than their performance. They think it's because of race, gender, orientation. Those are all protective categories, meaning if you are, in fact, terminated, disciplined, demoted, or any kind of adverse employment action, you don't have to be terminated, by the way. Anything that's just adverse, you can sue, and a lot of times people sue. The first thing that employees do, and they're required to do, is report it to the EEOC, the Equal Employment Opportunity Commission, or the New York State Department of Human Rights, the New York City Department of Human Rights. So that's the first avenue. You can't go to court right away. You got to go to the EEOC first, and then the EEOC will investigate. So a lot of times, a lot of my business owner clients would come to me and say, "I got this inquiry from EEOC," and they're pretty thorough. What the EEOC will do is they will ask you for the employee files of everybody, the employee handbook, everything, and then you're supposed to. They'll come in and interview you. They'll interview other people in the company. And then they'll do an investigation, and then they'll find either there's a probable cause for discrimination or no probable cause. Either way, the employee gets a right to sue, which means the right to sue letter is then your right to sue in federal court. That's where you bring it. But in any event, if you're found to have, there's probable cause of discrimination, then the business owner has to engage in settlement discussion. The EEOC would try to get some kind of settlement negotiation going between the employer and the employee. But if there's no probable cause, the EEOC just basically says, you know what, here's your right to sue letter, do whatever you want to do. And then the employee would sue. These are very costly litigation, so I don't see a lot of employees suing after receiving these notice of right to sue. And the dockets of federal courts and state courts are filled with employment discrimination cases. And I could say that from my experience, I used to clerk for a judge here in New York, and I've seen a lot of these. I would say like 90% of them are really just sort of, they're not going to see the light of day. Essentially, it's going to get dismissed. There's no basis for it. The 10% would move forward, and this is very costly. It takes forever to litigate these cases.
All right, when we come back, this is fascinating material. For those who are just catching us here, this is Taking Care of Business. I'm Richard Solomon. This is Tristan Loanzon, who is a small business attorney. He's located in Manhattan, LOANZON.com. So I said that wrong. LOANZON.com, 212-760-1515. We'll be right back. We're going to continue with some of the employment discrimination issues. One thing that I'd like to ask is sort of about age discrimination, because as people get older and more expensive, they seem to be being thrown out of places in order to be replaced by younger and cheaper people. So stick with us. We'll be right back. Thanks for listening.
What I really need, some kind of affection.
Richard Solomon welcomes you back to Taking Care of Business. This is our last FM-based segment, but if we have a little bonus overtime, you'll catch that on YouTube, where you'll catch all of our full shows, including bonus features and overtime and cool stuff like that. We are talking to Tristan Loanzon, who is a small business attorney located in Manhattan. So we share the small business, advisory role as counselors of law. We were talking before the last break about discrimination type cases. One quick sort of follow up before we go into the next question. Can you bring the discrimination case in either the state court or the federal court if you're the plaintiff, meaning the employee?
Yes.
Okay.
Yes. I mean, there are considerations for somebody, for a plaintiff, for a person who's been discriminated, whether to bring it in state court or federal court. I mean, I could talk about the differences, but I think that the main difference really is like people feel like they'll get faster justice in federal court.
The rocket docket. The rocket docket.
Yeah, but it's also a faster dismissal. I mean, right? So, but I think it's also in the federal court here, for example, in the Eastern District of New York, which covers Brooklyn, Queens, you will find that the court is very good about asking the bar attorneys to represent pro se plaintiffs. I'm part of the Eastern District of New York pro bono panel, and so a lot of times when plaintiff brings a lawsuit after they've gotten the right to sue from the EEOC, they would bring a lawsuit on their own, and you can do that. And so you proceed on your own, and then if you can prove to the court, you'll be asked by the court if you have the means to prosecute your case, and if you can prove that you don't. Some judges, a lot of judges in the Eastern District would find counsel for you. So I have actually represented a few individuals in the Eastern District who were pro se before. Pro se meaning representing themselves. I represented them, and for free. So they don't pay me, but I do this out of my pro bono sort of obligation. I feel like I need to do this. So I represented them. I got them through the litigation. We eventually settled the cases. But it's a good thing for the plaintiff. Otherwise, they wouldn't be able to prosecute these cases. Lawyers are just expensive, unfortunately. But if it's a meritable case, the judge would look at you and say, you know what, we'll find counsel for you.
Yeah. Now, what about age discrimination? I see a lot of that.
Yeah.
Because more experienced people command more money, and today's day and age is not about experience so much as just whatever the warm body that's the cheapest can really do will be good enough. In age discrimination cases, are you required to go to the EEOC or the New York State Division of Human Rights before you actually bring a lawsuit?
Yes, those are requirements. You have to what they call exhaust your remedies. So even if you feel like you've been discriminated or any adverse employment action against you on the basis of your age, go to the EEOC. Go online. It's eeoc.gov, and it's the best place to go. It has pointers for you. It has forms to fill out, and you file it and you sign it, and they'll investigate for you. So I've seen a lot of those age discrimination cases. Sometimes I've seen employers, because I've represented employers on this issue. We would basically instead of just terminating them, we would offer them a severance. Right? We would offer them some settlement agreement where, in exchange for this amount of money, we'll pay you, but you also release us from any claims.
Right, it's a buyout. You're buying out the claim.
Right.
Or a potential claim. Yeah.
A lot of employees and employers would do that. So if you're in a situation of being that employee, you always want to ask your employer for some kind of a buyout or a severance, it's always a good idea to ask, because there's always most of the time there's something out there waiting for you. You just have to ask. If you don't ask, you won't get it.
Now, is there a state equivalent of the EEOC?
Yes, it's it's actually New York City. It's the New York City Division of Human Rights. And
what if you live sort of outside New York City and you're affected by this, or something that's...
You just go to EEOC. EEOC.gov would give you the various, the different divisions, the different centers where you can go to. So let's say you're in Nassau County, they will tell you which office you should go to.
Okay. And let's say you're on the edge of the statute of limitations. First of all, what is the statute of limitations to bring such a lawsuit? From how many days from your the last time you applied?
Well, you have 360 days from the adverse employment action to make a report to the EEOC. Okay.
Right.
So you got a year. Once you have your right to sue letter from the EEOC, meaning that they've investigated and they've either found probable cause or they found no probable cause, regardless, from the time you receive that letter, you have 90 days to file.
Oh, so it's kind of quick.
Yeah, you have 90 days to file, so you can't just sit around. 90 days pass, it doesn't matter if you had the greatest case in the world, you're out.
And what about on the state side? Same thing? Wow.
Yeah.
All right, cool. What are the basic things that people need to, as employees and employers, need to be aware of? I guess as an employer, you need good books and records.
You got to get records. You have to well documented. If a lot of times with employers just sort of haphazard in performing an employment action, by suspending or demoting or terminating. They don't adequately document it. They don't state what the reasons are. So that's not a good thing, but that's just common sense. So you make sure you sort of document that you got paper trail for that. A lot of times, the employment discrimination happens when it's not exactly the president or the vice president, committing it, but it's say an employee in the department is sort of sexually harassing another person, and she reports it to the HR. Nothing gets done. So I think I see a lot more of those cases where it's your fellow employee basically harassing you and making it a hostile work environment. So employers need to watch out for those. They have to be very responsive to these complaints. Make sure your employment manual or employee manual has a specific steps that employees can take, that they need to take in order to complain. They have to state it. You have to state it in your employee manual that if you have something that you want to complain about, go through the chains. There have been court cases where basically an employee's lawsuit got thrown out because he or she didn't take advantage of the procedures provided by the employer. Right? So you got to make sure, as an employee, you follow those procedures. As an employer, you set out those procedures.
Wow. All right. Lots of good advice. All right. We have 10 minutes left. Let's do the lightning round. Small business owners, what are sort of the other strategies that they need to know about in terms of, litigating cases, hiring attorneys, hiring CPAs, the consequences of cost cutting or the wrong cost cutting? Why don't you just randomly throw out a bunch of ideas?
Yeah, I think I always tell my small business clients to be very careful about contracts. Hire a lawyer to review your contract. When you hire a lawyer, you always want to negotiate some kind of fee. A lot of times, there's this hourly fees really look sort of not applicable. I think slowly the hourly billing is sort of being thrown out of the window. So always negotiate with a lawyer. Like if you're going to hire a lawyer to review contracts, see if you can, propose a flat fee. Say one contract, this amount of money. So at least you're protected as far as like, he's not going to spend 20 hours on it reviewing a contract. So negotiate that, because you do have a lot of power as a business owner over a lot of attorneys on pricing, and a lot of attorneys would compete with each other on pricing. So make sure you always ask for that when you're hiring an attorney. As far as like, where do you find attorneys? I mean, other than sort of listening to this YouTube channel, I think a lot of times you can go to bar associations in the city of New York. There's so many bar associations, and they usually sometimes have a pro bono service. The courthouse has a pro bono service, so take advantage of that.
We'll also get recommendations from other business owners that you know. Who did they use? Who did they like?
Right.
Also, sometimes accountants know good attorneys.
A lot of times I get calls from accountants actually about like somebody, a business owner that they know who needs assistance. So, that's a good source of information. Oh,
and just one tip and strategy for all those out there. You don't necessarily want to rely on just one attorney for all your needs. There's all kinds of things that happen to small business owners. There's, sometimes the trucks get caught up with truck regulations, so you need a truck summons attorney. I actually do that. So if you go to nyctrucksummons.com, for example, you see an example of what I do. I'm not trying to push anything here, but just trying to give an example. Yet there are guys, and I don't do this, but there's people who like obtain liquor licenses for small business owners, and that's a whole bureaucratic process. There are attorneys that do all kinds of specializations. It's almost like the field of medicine where, you need like someone to fight the Environmental Control Board. Well, talk to this person. You need to incorporate Rich Solomon does that. You need an employment discrimination defense case. Call Tristan.
Right. Leases.
Yeah.
Right.
We'll talk about leases. Yes, that's also important because probably the biggest investment that you'll have in your business is equipment and leases for the equipment. So there's leases of equipment and leases of real property. Why don't you talk about that?
Yeah, I mean, the leases of real property, you definitely need to consult counsel on that because there's so many, they're multi-pages, there are writers to it. And so you could benefit from somebody helping you on that. But you also, again, you want to negotiate these fees. These fees are negotiable for review of leases. There are a lot of things to watch out in those lease agreements. I cannot outline them all. And also, in addition to, say signing up a lease for a store, there are also renewal issues. So
and escalations.
That's a litigated issue. That's a contentious issue sometimes, especially if the landlord's trying to raise your rent 100% or more. So those are the issues that you need to sort of deal with on lease. And on lease of equipment, a lot of those are really boilerplate. But, don't be fooled with the fact that they're pre-written. They are negotiable. So they should negotiate those.
Well, one point I'd like to make to people out there, I do some, office leases and things like that. And a lot of times you'll see in the boilerplate that you cannot, you waive your right to counterclaim, which means that if the landlord sues you, you have to waive your right to countersue. And I always say in my negotiations, that's against public policy. You're supposed to be able to litigate all claims, both the offensive claims and the counteroffensive claims in one lawsuit. So I always say it's really against public policy. Now, what happens is negotiating leases is sort of the preamble to how you're going to do or fare in a litigation. So right away, if you actually negotiate that, they have to take that out. Then if they do sue you, then you can countersue without having to get the motion to dismiss your counterclaim, which also, every part of litigation costs money. And the problem is more things that you either need to overcome or enforce or make motions on or to clarify, it just builds up the cost. So the more streamlined you are in your business, and the more streamlined you are in your litigation, where you're just fighting over very narrow issues, the better off you are.
Agree. Agree.
In the last 3 minutes, any good war stories or any other tips and strategies for small business owners? Let's talk a little bit. I don't know if you talked about cost cutting, but I know we talked about that in pre-production. Where do businesses put their money, and where do they, unfortunately, cut in the wrong spots?
Yeah, cost cutting. I mean, unbelievable. Maybe I can think of like 5 small business clients who decided not to hire an attorney to review their contracts, and they decided to. They're great business. They're great at what they do. Their doctors are represented. Represented accountants. They're very good at what they do, but they're not good about reading the contracts and hiring someone competent to review the contracts for them. And it's too late by the time they find out that they've entered into a pretty bad contract, and when they're getting sued. And that's, for me, it's sort of a perverse incentive, right? I mean, a lot of lawyers benefit from those screwed up contracts, because if there are no screwed up contracts, if all contracts are all, proper and to conforms to everybody's interests, then there's no need for litigation, right?
No, I don't know about that, because the truth is, I tell this to people all the time. I don't care what contracts say, it's about people's behavior. And a lot of times people just don't honor their commitments, or they look to shift responsibility. Because a lot of times people come to me and say, I need an ironclad contract. And I'll say, well, I can give you a well-written contract, but if the other side doesn't behave or play ball, then you know what? Then you have to go in there and sue them and enforce your rights. It's going to be expensive. You're going to be bitter. You're going to hate the process. It's going to be too long for your taste. And you're not going to like the bills, and you're not going to be happy with the result in the end, no matter what really happens.
I guess a good contract just basically discourages litigation. That's, I guess, one way of restating what I'm trying to say.
Okay.
A good contract really does reduces litigation or encourages parties to settle and discourage more attorneys' fees, because these contracts always have attorneys' fees, and to the prevailing party. In commercial contracts, if
we have 1 minute left, so if we have to spill over.
Sometimes the lease agreement would say if the landlord prevails, they get attorney's fees. You got to watch out for those. In residential contracts, for example, real estate contracts, if it says that, the law says there's actually a reciprocal right of the tenant to have the attorney's fees if the tenant prevails, but not in commercial contracts.
All right, so there we go. 1 hour of small business radio. So Tristan Loanzon, LOANZON.com, 212-760-1515. Thank you for participating. If you want, we'll do a quickie for our YouTube listeners and do a little quick add-on. But for those who listen to us on FM, thank you for being part of my radio family. Thanks for listening. Thanks for always checking in and making our YouTube site so successful. We'll see you in a week. Be safe. Be careful. Talk to you soon.
What I really need, some kind of affection.
All right, for all of those out there who are on YouTube, this is the bonus feature that makes YouTube, because we just didn't have enough time for the FM broadcast on 88.1 FM. So we're continuing with Tristan Loanzon, who is the small business attorney, and he was going to tell us, he was continuing his story about sort of these, attorney's fees, and you were going to tell us now something about a nonprofit.
Yeah, I represent a nonprofit in Brooklyn where the landlord essentially came into the premises and installed these waste pipes in their ceiling over a weekend. They didn't consent to it. Landlord said, "Hey, wait! The contract says that we have the right to do that." And my client says, "No, you didn't have the right to do that." So we litigated this case over 6 years. Oh. 6 years. Actually, no, it's a 2006 case. it's still going today, 2014. So that's like what? That's 8 years actually. So, but we prevailed. The landlord was found liable for breaching the lease, and so not only the landlord was found liable for damages for these pipes that stick out of the ceiling. These are waste pipes. These are sort of these heavy 8-inch in diameter pipes that carry sort of wastewater from the upper floors down to and connects to the sewer system down below. So not only was the landlord found liable for damages, but also the court found them liable for attorney's fees. So my client gets attorney's fees that he has paid since 2006.
Wow.
And so that was affirmed by the First Department. So now we're just trying to basically get the judgment down as to how much that would be. But the lesson for this, the lesson to be taken out from this is really, it helps to have good counsel to look at your agreements, your contract, and also, when you have a situation like this, is to have an attorney, a good attorney who's not too expensive, who's affordable, who can sort of give the representation. This is a nonprofit client. If they had hired a company like Skadden Arps, one of the biggest in town, they wouldn't be able to last 8 years.
Oh yeah, and look, the Fortune 100 has Fortune 100 level attorneys, and and then there's people like you and me.
Yeah, and we're good at what we do.
I used to represent the Fortune, without going into too many specifics. I was an attorney for one of the Fortune 3 companies at the time, and I was part of an army of lawyers when I first got out of law school. And now I was a small cog in this army, but this was a very, very big, very, very big company. I represented some big companies, and I did learn a few things from that. But well-resourced litigants actually do much better than people who are, resource-strapped.
Yeah, that's what you'll find. I mean, sometimes small business owner cannot afford legal representation, and so they end up either settling for a little amount, or just not pursuing the case, or just deciding to fold and get a judgment against them. It is unfortunate, but I think now there's really a movement now that sort of is going away from the hourly billing. And you see this a lot in big firms and medium-sized firms in New York. They're moving away from this hourly billing into what you call either a hybrid type of billing, where they charge you, say, on a hybrid basis, they would say, I'll take a contingency on the back end. I'll take, say, 10% of whatever you recover, but I'll only charge you, say, a certain dollars per hour. So there's an hourly part and there's a contingency part. So that's a hybrid. And some people also do just a flat fee, for.
Right. And for those out there listening, there's no such thing as a defense contingency. There's only a contingency when you're bringing an action as opposed to really defending an action. And by the way, there's no such thing as a contingency in criminal law. It's not like, no, seriously, I would think that's like an ethical rule.
Right.
You can't, something like that. One thing that people need to be aware of, and let's talk about this a little bit, is the army of lawyers problem when there are legal fees at issue. I remember a case that I had, a war story. A particular well-known landlord attorney firm in New York came in on a commercial case. They had 3-4 lawyers. Another one they called coming to court. Sadly, they won. I dispute that they should have won. The persons that I represented, I think what happened was it was fair that they lost, but I'm not sure that the blanket group of people that they sued on all the personal guarantees, and some of them I argued, were expired as against even co-defendants. Anyway, so what happened was after they got their judgments on the sort of the substantive thing, which is the lease and the acceleration of all the rent that was past due, then they brought a sort of second round of litigation, and it was all over their attorney's fees, and their attorney's fees exceeded the amount that they were seeking for in the accelerated rent. And these are major avenue midtown rents. So you can imagine what the attorney's fees were like. And one of the things that I sort of argued was, you got to be kidding me. One attorney is sufficient. I don't know why you need three people, and then the person you call in the big booth with the head, the Motorola headset, the coach, like in the NFL. So yeah, and the court awarded them everything, and our side just got crushed. I don't know that they should have been crushed to the point that they were, but I didn't see that as just. So, and there were a lot of defense attorneys on the side of the defense, and I think we all felt like, wow, we were just brutalized.
Yeah.
Anything else for our YouTube people out there? Anything you want to talk about or highlight or promote or talk about from your website?
I think you'll find on my website some of the things that we've done for clients, and some of the things that we call it sort of creating value for your business. Our proposition is that lawyers should add value to your business and not extract value from your business.
That's the government's job.
And they're good at it too.
They're great at it.
So yeah, it's lawyers like us, you, Rich, me. I mean, I think what we do is we add value to the client. We add value to their business, and so that's we feel very happy and proud about that.
One last topic to talk about is the amount of fines. If you're in sort of cash-strapped cities such as New York City, you'll see that there's sort of a regulatory scheme of you either need a permit, and then we're going to give you a fine for not having a permit, or if you did have the permit, you didn't follow the permit. And the fines are brutal, and they're excessive, and a lot of different kinds of agencies can issue them. In New York City, it could be the Department of Buildings. It could be the Department of Transportation. It could be the NYPD Traffic Intelligence Unit. I mean, it's sanitation. There's just fire department.
Fire department, yep.
There's a never-ending list of agencies that can issue you fines. The fines are not cheap. They're very tough to litigate. In my opinion, the administrative courts that adjudicate these things are very, very tough. In many ways, it's like a conflict of interest, in my opinion, that the people who are prosecuting you are one part of the government, and the people who are deciding it is another part of the government. It's not really like going to courts where there's a independent judiciary who really, they don't look at revenue to decide cases so much. Now, I know this is opinion. I'm sure I'll get a lot of flack for this, but I know that a lot of business owners who are subjected to a lot of these fines and regulations and regulatory fines and repeated fines really feel that it's just sort of another way of extracting revenue because they can't tax you anymore. They can't raise the tolls anymore. I mean, as it is, the tolls are astronomically high as it is. The taxes are as high as they can be, and it's sort of like, well, we need to get more money out of people, so let's just issue more fines, more tickets, more summonses, more everything.
Yeah. Makes sense.
So to the extent that you could stay away from fines, summonses. In fact, a lot of people just don't do business in the city of New York because it's just too tough to do business here. You can't, double park a vehicle. Can you imagine a moving company trying to move you in and out of an apartment or office? Unless they do it at 3 o'clock in the morning, to do it during the daytime is almost impossible. And of course, the traffic police are there, and they're always giving tickets. And the system is really just designed to hit the business owners, and then they pass it along to their customers.
Something came to mind, and be very quick, but maybe the topic of the next YouTube is insurance. A lot of small business owners either don't have insurance, and if they do have insurance, they don't notify the insurance company of claims. So by the time they need some assistance, the 30-day notice of claim has expired, and they can't claim insurance anymore. So insurance is also a topic that I have to deal with a lot with small business owners. So
get yourself a good insurance broker, and make sure. A quick war story. Represented a guy who was a painter, and he basically said he had painter's insurance. So I looked at his insurance because he got sued and he got disclaimed against him. It said, what is the policy? It's a painting policy. What is excluded? Painting. So I'm saying, wait a second, they sold you a painting policy and they excluded painting? And it was basically so he bought something that gave him a document to show somebody that he was insured, but nobody read it. And as a result, he was in all this litigation. It just hemorrhaged money. It was just terrible because he didn't have the right insurance. In fact, I see that a lot. I had a very, very big litigation where there was a massive injury, and the client thought they had insurance, and they didn't.
Oh.
They didn't have the right kind of insurance. They didn't have the right kind of what they call riders, RIDERS. And as a result, they were self-insured on a big defense, and that was very, very rough. So have the right insurance. That's a very good point.
Right. Insurance.
All right. Tristan, you've been a gem. You're a gentleman and a great scholar. Thank you. For everybody out there, LOANZON.com, 212-760-1515. And you can always send us an email, TCB Radio WCWP. I'll say that slowly. TCB Radio WCWP at yahoo.com. And we can always forward anything to Tristan on your behalf, or contact him directly through his web or by telephone. Thanks for listening, and we'll see you again on FM and on the web.